Good afternoon, everyone. My name is Jeff Newman. I am a partner at Thompson Coburn here in the Washington, D.C. office. We're fortunate to have as well my partner from St. Louis, who is in the St. Louis office and is live before many of you right now who have been able to attend in our St. Louis office downtown, Kevin Kircher, who's a partner in the Intellectual Property Group. Today we're here to talk about intellectual property and how two worlds collide, the world of government contracts and the commercial world, whereas normally intellectual property runs between those two industries and sectors. Often is the case that the rules are very different between the two. And our goal today is to walk you through some of those differences, some of the similarities, and some of the concerns and some of the issues that you would face when working with the federal government, but also in the commercial context. I'd like to talk about four main things today, and that is the valuable types of IP to protect. You know, there are many types of intellectual property. There's patents, there's copyrights, trade secrets, trademarks and service marks, know-how, industrial arts, and the list goes on and on. But the main type of intellectual property we deal with in the government marketplace are really three types, and that's patents, technical data, and computer software. And that's going to be our focus on the intellectual property analysis today. We also want to spend a little bit of time on the treatment of intellectual property rights, not only between the commercial world, but also between the government contracting sector. And by that I mean between the military and civilian programs. Even some of the most basic definitions dealing with intellectual property in the regulations are different in and of themselves. It's also important, I think, to take advantage of commercial item provisions under the applicable government contracting regulations. In the commercial world, it's often two parties just negotiating between each other, coming up with terms and conditions that they're comfortable to live with, of course, in accordance with applicable, state and federal laws. But in the government contracts world, there are standard terms and conditions that are flowed down, but a relatively new way is commercial item contracting that we're seeing more and more of in the commercial marketplace. And we'll talk about the flexibility and the streamlining aspects of working with those type of agreements. And last and certainly not least, we'll talk about some of the key issues when we license technology in the government contracting space and how those licensing requirements also play out in the commercial fields as well. Because at the end of the day, understanding the rules and regulations and the requirements when you license are essential to make sure that you protect your crown jewels or assets of the company. I also would be remiss to say, and we'll also talk about it in the key issues during the license agreement, is the importance of marking and disclosure obligations, especially in the government contracts context. Well, we certainly can begin today with patents and the rights to inventions in government contracts. And also, as I mentioned before, Kevin will have a few comments in a few moments discussing how those patents and inventions, the interplay between the government contracting context and the commercial marketplace. But the best place to start with patent rights is, what is the U.S. government policy on utilizing inventions in the government contract area? And that is commercialization. And really it started back in 1980 when the patent provisions were standardized based on a statute, the Bayh-Dole Act. And that statute is implemented under the FAR Part 27, 52.227-11, and those regulations govern the rights to inventions of contractors working with the federal government. As I mentioned, it's designed to promote commercialization, and by that it means to promote new and non-obvious developments, and it's certainly a powerful tool for attracting investment. Key to note here is the rights in patents in the government contracts context involves title to inventions. It's not technical data or software such as engineering drawings and source code, or as we like to refer to as trade secrets. What we are dealing here with is licensing of the invention. And here the focus would be on subject inventions. And as many of you may know, a subject invention is contractors can obtain title to those subject inventions that are patented. If you have a subject invention, and we'll talk about the definition of subject invention in a moment, contractors can obtain title to those subject invention, and the government gets a paid-up, royalty-free, non-exclusive license that's non-transferable to have that invention practiced by or on behalf of the government. And that's a fairly broad application, the practice by or on behalf of the government. So what that means is that invention can be given to a competitor as part of a bid package. And those patented information can be utilized by other contractors in satisfying the government's requirements under another acquisition. So it's important to understand that license that the government gets is a potentially broad application. Should mention, and we'll talk about in a few moments as well, is that contractors can lose title if it does not report the subject invention or fails to commercialize the invention in a timely manner. We also will note that, as I said, the subject invention definition is critical. So what is a subject invention? A subject invention simply is an adventure of the contractor that is conceived or first actually reduced to practice in the performance of work under a particular government agreement. And then once again, the failure to elect title to an invention gives the government certain rights, gives government title to the invention, but the contractor could still obtain certain rights to maintain use of the invention, even though the government has title. But there are really two key events dealing with the subject invention, and that is first conceived and the first actual reduction of practice. And what does that mean? Well, the easy one is first conceived, and that is when the invention is thought up or the solution is created. Generally, that gives rise to conception under the government contracting rules and regulations. The first actual reduction of practice, I think, is the more interesting of the two. And, certainly building a prototype of the invention, that's usually the most expensive or riskiest way to proceed because you have to outlay substantial funds and resources to do that, is one way to constitute a first actual reduction of practice. It's important to note, however, that filing a patent application in and of itself is not a first actual reduction of practice. In the commercial world, that would be okay to get a patent on an invention. But in the government contract world, the mere filing of an application is only a constructive reduction of practice and therefore does not give rise to a subject invention. And certainly, contractors who expend the efforts on a government contract or involved in a government program, want to maintain and elect title to the invention if at all possible. So what can the contractor do? Well, the contractor goes through the process of notifying the contracting officer that it wants to obtain title to the invention, the subject invention, and then the government gets its standard, what we call the by-dole license. And so the government can utilize the invention as we discussed before. But what happens if the contractor either fails or does not elect to timely disclose the invention such that the government takes title to the invention? If the U.S. government gets title, contractor rights are, and we could look at this in two ways. One is if the contractor fails to elect or pursue a patent, and that's, once again, the failure to elect or pursue a patent. The contractor gets a license to use the invention. It's revocable, non-exclusive, paid-up license to include the contractor subsidiaries and affiliates, and the contractor has the right to sublicense that invention. That license is non-transferable absent the approval of the contracting officer, because the contracting officer, representing the government's interests, wants to make sure that the invention will be utilized properly and is being transferred in accordance with the government's best interests. And the license is certainly revocable or modifiable by the government if, in fact, the government wants to do so for various reasons, including to achieve practical application. More importantly, and more draconian perhaps, is the failure to disclose the invention. In the government contracts context, the failure to disclose the invention, sort of a, oops, we made a mistake, or we're too lazy to come up with the paperwork to submit, or we just don't feel like doing it. Different than the failure to elect or pursue a patent, a conscious decision, the failure to disclose the invention could mean the forfeiture of all rights to that invention. So not only don't you get title to the invention, but you lose the right to have a license to that invention as well. A little bit different, certainly in the commercial context, where the parties can negotiate their rights. But I'll introduce Kevin now to sort of talk a little about some of the commercial aspects of failing to negotiate the proper title interest to a particular invention.
So the results can be really harsh. In the U.S. now, we've gone from first to invent to first to file, and so therefore, the first party to file on the invention will get the rights to the invention. And so if you wait and someone else files on the same invention, they could end up owning that invention. Also, there's always laws in order to prevent people from just holding on to a patent and not holding on to an invention and not obtaining patent protection right away. And so in the U.S., you have a 1-year period from when you commercialize or publicly disclose an invention to file the patent application. If you don't do that, then you'll be unable to obtain a valid patent. In other countries, they have what's called absolute novelty, and it's very harsh. Any commercial disclosure can automatically terminate your ability to get a valid patent. And so you have to be very diligent in order to kind of make sure you pursue your rights, because otherwise you could end up with no rights, or you could end up potentially being sued by someone who actually came up with the same idea at a later point in time. And so that is something to really keep that in mind. There are a number of disclosure requirements. Under the DFARS, basically, you have 2 months to disclose the invention to the contractor, who's responsible for the person who's responsible for patent matters, or you have 6 months after you become aware of the invention, the subject of the invention, whichever is earlier, 6 months of discovery of the invention. And so basically, you have these 2 time periods. And so whichever is the earlier one, because they want you to, as the government contractor, to disclose it immediately and right away to the government, not just sit on if you have a patentable invention. Under the FAR, the non-defense regs, you have 2 months from disclosure for the contractors responsible for patent matters. Also, you have a time period in order to elect title to the invention, where you're going to say you want to retain ownership to the invention and give it to the government. So you have 8 months in order to disclose to the contracting officer, and 2 years of it under the FAR to disclose it to the agency. But you have to be sure you could have title before you can elect title. An interesting case in that is Supreme Court case is Stanford versus Roach. Next slide. And basically, this is a matter where we had an inventor who was actually a professor with Stanford University. And prior to that, he actually worked for, it was a company that was acquired by Roche Diagnostics. And basically, when he was working for Roche, he signed a very specific assignment. Here's the one for Stanford, which occurred later, and it's just very general, in which all inventions he came up with would generally be assigned, but it was not very specific as to what he would sign. It's inventions in the future that may arise, and so it's very amorphous terms. And so it wasn't anything very specific, and he had already made an assignment to this Cletus organization, which is someone who's acquired by Roche Diagnostics. Next slide, please. This is what he signed, the CETUS. Basically, it was where he went and visited, and he will hereby sign all rights to the ideas, inventions described in this paragraph. And he did that previously, and that basically kind of governed the transaction. In the patent law, the inventor is the actual owner of the invention. Until that inventor actually gives the rights away, they are assumed to be the owner. And so a main item here is under government contracting law. Even if the entity like Stanford University had a viable government contract, unless Stanford can get a very on-point agreement to assign those rights from the inventor to Stanford, it still resides in the inventor. In this case, the professor had already owned it. This is for an HIV diagnostic treatment type of technology. And so basically it was already determined by the Supreme Court that the inventor had already given his rights to Roche Diagnostics, and just because Stanford had an agreement under a government contract where theoretically all inventions under this government contract is supposed to belong to the government, since Stanford never validly got the rights from this inventor, it was held that they could not transfer it. Next slide, please. Whoops. Let's see. There we go. Under 35 U.S.C. 202, this is what Stanford is trying to argue, that federally funded contractors can elect to retain the invention of an invention conceived or reduced to practice under a funding agreement. And they argued that the above language encompasses all that work that was done under the federal funding agreement. Next slide, please. So basically, and the Supreme Court held that they're not going to change the basic law, patent law, and that the inventor would still own the invention until it was validly assigned. And in this scenario, the inventor had assigned it to Roche Diagnostics, and therefore they were the owners. And this agreement to assign potential future inventions was held not to be binding. And so the law really did not change. This government contracting law did not change the basic fundamental understanding of the principles of law in which the inventor holds the rights to the invention. Other inventions that are required in order to have a valid patent, you've got to file a patent application before 1 year. You've got 1 year to elect, and you've also got to file before what's called a statutory deadline. I kind of alluded to this before. The statutory deadline is basically the law tries to prevent you from using an invention for years and years and exploiting it, and then deciding, let's say 10 years down the road after you've made millions, now I want to get a patent on it. And so they put a deadline on that of 1 year in the U.S. in order to get a patent. So you can't commercially disclose it to people, you can't use it in your factory, you can't sell it to people, have commercial sales, and without starting this 1 year time limit. In other countries, like most countries in Europe and in Asia, it starts automatically. You cannot commercially use it or make a commercial disclosure without losing your rights. And so those are kind of your two requirements. You have a 1 year election, but also you have statutory bars that could rise up. You have other reporting requirements under the government. You have to report if you're filing the patent. You also want to report to the contractor if you're abandoning the patent, because it's up to the government needs to know that. It's kind of the trade-off for you retaining your rights to the invention is that when you should be able to tell the government that they have the option to pick up the patent and get the ownership if you don't want it anymore. If you're no longer interested in paying maintenance fees, it's the same thing. The government wants to know because they don't want to belong in the public domain, and they want basically a first option to be able to protect it. There's also annual reports to show how the invention is being used. You have to make on an annual basis. Just let the government know this is what we're doing with the invention. Here's how the technology is being exploited, etc. Just so the government knows what is transpiring, because essentially you've kind of done it under the government contract, and therefore they feel as a trade-off for you retaining title to the invention, you have to kind of keep them in the loop as to what's going on. There's also obligations under the United States Patent Office as far as just basically filing restraints. Like when you file the patent application, you've got to have it's got to be definite. You've got to put in the best mode of the invention, which means the best way you know how to make the invention. You've got to describe it in detail. You've got to file it within the certain timelines. If they have any objections to it and say you've got multiple inventions in the same patent application, you have to respond to that. And so there's numerous things that can come up. Also, the Patent Office does its own patent search and typically comes back with a rejection. You have to respond to those rejections to keep the patent alive and be able to say, well, this is our invention, this is why it's different than what was cited by the examiner, and keep moving the case forward to prosecution. Next slide, please.
Kevin and I, we work together quite a bit on different licensing issues for government contractors who work both in the commercial space and the government contracting space. And one of the issues we wrestle with clients all the time is the idea that what happens if you fail to commercialize, and contractors are correctly under the belief, and I say that correctly under the belief because they believe, and by the regulations rightly so, that the government can come in and take rights to their or take title to the invention that the contractor was provided if the contractor doesn't commercialize the invention or take steps to commercialize the invention, if there's a health, safety, or welfare issue, if there's a public use issue specified by federal regulations, and such requirements are met that would warrant the government for taking title to the invention. That is something called march-in rights. And Kevin and I discuss this quite frequently with clients because really it is really much ado about nothing. And I say that because the government has never exercised march-in rights in the past, and it's highly unlikely, and I mean highly unlikely in all caps, that the government would ever exercise march-in rights and take title to an invention that's been granted to a contractor. And you could ask yourself the reasons why. Well, as an inventor or as a large government contractor who is providing technology to the government, if in fact the government came in or marched in and took or usurped a contractor's rights to a particular patent, what would happen is it would create a tremendous chilling effect in the government contracting sector, and contractors and companies would be very reluctant to enter into business with the government, especially companies that do both commercial and government contracting. So once again, there's some cases out there that dance around the issues of march-in rights, but at the end of the day, it's fair to say that the government has never exercised those march-in rights. But I'll let Kevin sort of comment a bit on in the commercial sector if there is a unique or similar provision in those set of industries.
In the commercial side, it's not really that uncommon for people not to commercialize inventions. There's numerous patents out there where people have it. And there are a variety of reasons. It could be it's just there's really no market. It could, the price point for it could be too expensive. There could be more commercially viable alternatives. And so it's not uncommon for people not to always practice invention. The key is there are expenses. You have to keep patents maintained. In foreign countries, every year you have to pay an annuity. In the U.S., you have to pay maintenance fees. And so it's analogous to real estate where you have real estate property taxes. You'll have to pay expenses and things like that. So you want to use your patents. At the very least, you want to be in a business where you can put that together as a portfolio, as an asset that you can sell at some point to investors and increase the value of your organization. And so, but there's nothing really too draconian about not having commercializing it. It's just an unnecessary expense if you don't.
What I think Kevin and I both find more interesting are the domestic preference requirements, or the U.S. manufacturing requirement under the Bayh-Dole Act. It's Section I of the U.S. 35 U.S.C. Section 202. And what's really interesting about this, and there's been a lot of scrutiny of this particular provision, especially a few years ago under many of the stimulus programs, and that is the preference for American industry requires that prior to the subject invention being exclusively, and please underline exclusively if you're taking notes, but prior to that subject invention being exclusively licensed, the contractor must require the exclusive licensee to manufacture the subject invention substantially in the U.S. And the code section, I should have said, is 35 U.S.C. 204, not 202, but 204, subsection I. That provision can be waived if, for example, there's no available manufacturing sources here in the United States, or there's a public interest that can cause the domestic preference requirements to be waived. Generally speaking, to say that it costs more to manufacture in the United States than overseas, generally that is not, and I've never seen an instance where that is a permissible exception or support for granting a waiver. So, and if you fail to comply with this U.S. manufacturing requirement or preference for American industry requirements, the government can march in to allow the government to grant a non-exclusive rights on its own. But once again, the government has never exercised those march-in rights. What's really important to note here, though, and when clients call us about this particular issue, the first question you have to ask yourself, are we dealing with an exclusive license situation? I mentioned to underline exclusive license, and I said that because if we're not in an exclusive licensing relationship, this provision does not come into play. And the manufacturing requirement here in the U.S. is not an issue. So, and if it's not exclusive, you are free to proceed with your manufacturing or sourcing decisions as you see fit. But when you're dealing with an exclusive licensee, that is when you have to sort of consider some of your sourcing and manufacturing decisions as you make your product.
And on the commercial side, there really isn't a lot of ramifications. I mean, you could have kept a tax deal to be located in a certain locale, or I worked in-house for a Milliken & Company where they had a certification mark made in the USA where they had to actually make it here in the U.S. But overall, typically, on the commercial side, you can make the product where you want it. There's a lot of marketing repercussions. If you've been touting it as American-made products and things like that, and all of a sudden you move overseas, you can't make false representations. You could potentially lose some customers, but overall, there's no real draconian aspect to it. Clients relocate to for economical reasons overseas all the time. So.
Well, this one will shock a lot of people who are not involved in government contracts or not involved with intellectual property in government contracts, and that is if the U.S. government or a contractor uses a patent without permission, that is deemed not to be an infringement. Let me say that again. If the government or a contractor uses a patent without permission, the use of that patent is deemed not to be an infringement. And we'll talk about the reasons why in a moment, but what is it deemed to be? It's not an infringement, but the government recognizes the nature of the use of someone else's patent, and so therefore the sole remedy is a reasonable royalty. And there's no injunction that's normally granted in the commercial or available in the commercial context. There's no treble damages. There's no attorney fees. And the sole jurisdiction is in the Court of Federal Claims. And once again, if you're in the commercial context and a commercial partner or competitor used your patent without permission, that would give rise to infringement, and they could be that partner or competitor could be sued for patent infringement, and you could recover. Not only can you get an injunctive relief and stop the process or the manufacturing process or the distribution, but you could go ahead and get treble damages. Why is this the case? And what I would say is that, why is this the case? Well, there's something called the authorization and consent clause. And that's a unique clause in the world of government contracts that provides an affirmative defense to an allegation of infringement. You could find that clause for those interested at FAR 52.227-1. The authorization and consent clause must be raised by the defendant as a defense to a claim of infringement under the government contract. And there are two types of infringement. There's direct infringement, which is the use of manufacture by the U.S., and there's indirect infringement, and that's the use of manufacture for the United States. So indirect infringement is the use of manufacture for the United States, and direct infringement is the use of manufacture by the United States. We should note, however, that where the contractor's use exceeds the authorization and consent clause, the private contractor may be enjoined by a company bringing the infringement suit. So as long as the use is covered under the government contract through the authorization and consent clause and they're operating within the scope of the contract, we have the sole remedy is a reasonable royalty, and the sole jurisdiction is in the U.S. Court of Federal Claims here in Washington. No injunction, no treble damage, no attorney's fees may be awarded. And so therefore, under the authorization and consent clause, to summarize, the U.S. government authorizes patent use by contractors and consents to be sued for patent use. That's how they got the name authorization and consent clause. It's interesting to note, though, for commercial items, the U.S. government requires that a contractor indemnify the government for potential infringement, and that's under FAR 52.227-3 and FAR Part 27.201-2, C2. C is in Charlie, 2. That can be waived. That requirement can be waived, and that's again in the clause at 52.227-5. And similarly, we should also finally note that the U.S. government can indemnify contractors for patent suits. And generally, as many of you know, the government generally does not indemnify contractors, but they can indemnify contractors for patent suits for commercial items in accordance with the provisions that I just cited above. Let's take a moment now and switch to technical data and computer software. Generally, when we deal with government contracts, we treat patents and inventions differently than we treat technical data and computer software. Why do we do that? Well, unlike patents, where we're dealing with corresponding title concerns, here the focus is on a license to use the data or software and any related restrictions. Now, before we begin the discussion, I often ask clients and companies, and I would share with you 3 main questions to ask yourself. And the answers to these questions will determine how to treat data and software that you are looking at in terms of how to protect. The first question is, are we talking about technical data or computer software, or both? Because technical data and computer software, the regulations are similar but can also be slightly different. Number 2, are we dealing with a DoD or military acquisition, or are we dealing with a civilian acquisition that we would subject to the FAR, or Federal Acquisition Regulation? And the third question to ask yourself, are we dealing with a commercial item subject to FAR Part 2.101, and we'll talk about commercial items toward the end of our program, or are we talking about a non-commercial item, standard, government acquisitions? The answer to those 3 questions, as I said, will tell us a lot about how to protect the software and data. Rights, when we deal with technical data and computer software, are generally determined by who funded the data or software developed or delivered in the performance of the contract, and delivery is important. The data and software has to be a deliverable under the contract before the license rights will be granted to the U.S. government. Let's talk about technical data before we talk about software. What is technical data? It's really, as the definition on the screen implies, is recorded information of a scientific or technical nature regardless of form. Some examples: drawing, research methods, designs, and processes. And more specifically, things you may see on a regular basis if you were a government contractor: mechanical drawings, circuit schematics, printed circuit board layouts, assembly instructions, acceptance test plans, reports that are required to be delivered to the government through presentation packages for program design reviews or contract design reviews. And yes, software development plans also constitute technical data and not computer software. And that's why it's important to read the definitions of both to see which one applies. I should say recorded information is not know-how. Know-how is not covered by the data rights clauses. That's addressed usually in technical transfers. Technical data also includes computer software, obviously, but it also excludes financial data and management records. It does not apply at all to hardware. So really, and there's a list of examples in the FAR when you parse through the regulations of what constitutes technical data and computer software.
Computer software is a wide variety of different things that fall under it. It's not just what you would expect, which would be the source code or the object code. It also includes design details that are used to kind of create the software, algorithms, flowcharts. It's kind of the software and things closely connected to the software. And so it's got a very specific definition. And the most important aspect of it is, if you get anything out of this seminar, the most crucial thing is determining beforehand where the money is coming from when you develop software. If you have software that is going to later be contributed to by the government and developed with government funds, that's governed by one set of rules. If you've developed it yourself on your own money, you retain virtually most of your rights. And so it's 2 different things basically, you've got kind of gradations on what is owned, and if you're able to differentiate that and keep tabs of that, both from a monetary viewpoint and then kind of be able to isolate what that software is and who contributed what to it, you can have, you can really control what rights the government has, whether they can disseminate it throughout the government without any thought, or whether it's restricted and still is basically only be used for the purposes of the contract. Under this rule, under the DFARS 252, 227, 7207, and under the FAR 52.27 are the two applicable regulations governing computer software. Next slide, please. The rights in technical data and computer software, basically, like I said, kind of detail with the funding sources. And so if the government funds it at all, completely, basically they have unlimited rights, and so they can do whatever they want to the software. They disseminate throughout the government. It's kind of the equivalent to having an expensive sports car that the government has. They don't have to pay for the insurance or the gas or anything, but they can do whatever they want with that sports car. And it's kind of that's analogous to what unlimited rights, so to speak. They have the best of both worlds as to what they can do with the software. Limited and restricted is beneficial to you because you're able to kind of control. This is where you fund it. Totally, you're able to kind of control who has rights. You have rights to it, and you can curtail the government's ability, so to speak. So it's used just for a specific contract. They can't disseminate throughout the government. They don't have unlimited rights, and therefore that's the optimal. And so you need to take care when you're going into these scenarios is be able to identify what you've developed yourself, keep that pristine if possible, and identify what you've developed yourself. And then moving forward, look at strategically, if you're going to move forward and you've got some software you know you have to have, would be better to finance it yourself or have the government involved where they could carte blanche to your software. And so those are the two main categories. A mixed one is government purpose rights, which is kind of a mixed funding, used for the Department of Defense only, and that's kind of a combination where both you and the government have provided funding. Another ability is specifically negotiate license rights. Like sometimes you have like commercial software, you can use a standard commercial software agreement, which the government actually encourages, and therefore you'd have even more rights because you can limit the number of computers beyond what you can do with it. You can't disassemble it, you can't reverse engineer it, and that's also an optimal thing. The contractor remains the owner of the data in the software and can use these assets freely unless specifically restricted. The government essentially obtains a license, not title. And so it's like I said, the government essentially can go into the sports car, drive it wherever it wants if it's got unlimited rights, and they don't have to worry about filling up the gas tank, paying the insurance, whatever. That's handled by you, so they have the best of all worlds. And these are the standard license rights. In some cases, you can specifically negotiate rights, and it's up to the government whether they're willing to agree to that or not. But those are the main categories. And so strategically is how you want to look at it and figure out how you can maximize and put everything as much as possible into the limited restricted rights. And so the main challenges with clients, if you can, is coming to us much later when things have been done and totally developed. It's a lot more difficult because sometimes you have software and the client doesn't realize where all the funding came from. They didn't keep tabs of it. They don't know exactly where it came from, and so that can be a frustrating experience for them. There's also designations under the regs. You have to mark what category it's in. Marking is crucial, and so you have to tell the government when you give them the software or the data, you've got to mark on it what category it falls in, so you need to be able to do that also if you want to preserve those rights. And so the key is to strategically kind of look forward and say, okay, here's software, these are the company jewels, we want to protect this, and so we want to pay for this ourselves because we don't want this to disseminate throughout the government. We want to retain rights to this. And so therefore we're going to be willing to make that investment. If there's some new software you need, maybe make that in a version, if it's something only the government can use, it's a module that interfaces with your software, and it can only be used in this purpose, then if the government has unlimited rights to that, that would be acceptable. You can live with that. And so you have to kind of look at every avenue, but what you don't want to do is just kind of put it all together in a software stew and not know where the money came from, not be able to parse it out. You want to be able to kind of, in a lot of cases, it's good to have specific modules, and so you can say this one is ours, this module is the government's, this is somewhere in between where there's government purpose rights, and so at least you can strategically be aware of how you maximize protecting what you consider the most important, and you let the government have things that aren't a necessity that only the government maybe can benefit from that really isn't crucial to your business. And so those are all things to kind of strategically kind of keep in mind and kind of pursue.
And one thing we should mention is that, these sort of rights allocations are important certainly in real time, and you want to make sure you identify your software or data correctly and you mark it accordingly. But often is the case, parties do that, the agreements go in the drawer, and 6 years, 6 months, not 6 months, but 6 years, 16 years, my record is 35 years, government comes back and says, we have rights to that particular technical data computer software, and you go to try to find the records. And you have no accounting records, you have no engineering records, and you're really at a loss then to defend your rights to that particular IP. So it's really important as we go forward with the modern age of technology to be able to save these funding allocations and financial records to make sure that you can establish and support your claims to your allocations of IP rights.
And so kind of emphasizing again what unlimited rights is, basically the U.S. government can use or disclose the data for any and software for any purpose, and they can even publish it. And so there's nothing more frustrating to someone to have the government publish what they consider to be their crown jewels kind of software or data that they provide them a competitive advantage, and that's published for everyone to see, just because it's kind of blended in. And the client can't differentiate what the government paid for and what they paid for. They can also grant third parties the right to use the same broad rights in data and software. So the government has unlimited rights to do whatever they want with the data. And so strategically you want to keep as little in this category as you possibly can, because unless it's something where only you don't care if the government has rights to it. But if it's something you find really crucial, you definitely want to keep as much out of this bucket as you possibly can. Next slide.
With government purpose rights, this is sort of the trick question when I do these presentations in person. I'll go through a list of rights that are provided to a particular piece of computer software, and while we don't have time to discuss the doctrine of segregability today, where a piece of software may have 3 or 4 different types of rights allocations allocated to it, depending on if this is a civilian or military acquisition, you have to remember government purpose rights only applies to military acquisitions or is only available under the DFARS. If in fact this was a mixed funding situation through a civilian agency, no matter if the government put in 1 penny and the contractor put in $20 million, the default position is not government purpose rights. The default position would be unlimited rights, as Kevin just discussed. But government purpose rights, once again, available only in the context of military acquisitions under the DFARS, and the U.S. government under government purpose rights can use technical data or computer software within the U.S. government for government purposes without restriction. So what does that mean? That means, similar to what we talked about on the buy-dole license, is that the U.S. government can authorize third parties to use government purpose rights, technical data, or computer software for any government purpose, so long as it's used within the government. And primarily, this means for purposes of reprocurement. And so let me give you an example. Let's just say you're working on the ABC program under a Navy contract, and the Navy loves your drawings and designs on this ABC program. and some intuitive and smart contracting officer says, you know what, we can use these contractors' design drawings on our corollary XYZ program. They can take those design drawings without compensation or without permission and give those to competitors under the XYZ program to use for purposes of that acquisition and that bid package. That's perfectly permissible. Now, contractors cannot charge the government for those rights to use GPR or government purpose rights data or software, but the data or software is certainly protectable in the commercial market, and those contractors who are receiving or companies receiving the data or software with GPR rights cannot use that for commercial purposes. This certainly has a broad effect if there's no commercial application for the data or software. And certainly any engineer worth his or her salt probably could reverse engineer some data or software from looking at these drawings or other designs or other corresponding intellectual property. So it's important to understand the limits of government purpose rights and the obligations that come with it. I should say, when working with government purpose rights, contractors are required to sign either NDAs or there's a standard clause in the under the DFARS that requires the non-disclosure of this information for commercial purposes. But by and large, the government can take this data or software with GPR, give it to competitors for purposes, as I said, as an example of other reprocurement, and that happens frequently as the government is trying to create more second, third, fourth sources for a particular technology item. Talk briefly about limited rights technical data. And we'll talk a little bit about restricted rights computer software. And once again, another red pencil moment for those of you not really involved in government contracts all that much. When we talk about limited rights, we're just talking about technical data. Limited rights means nothing with computer software. That's restricted rights. And as I said, we'll get to that in a few moments when we talk about computer software. But limited rights technical data may be reproduced or used within the U.S. government and may not be disclosed outside the U.S. government, and it may not be used for manufacturing purposes at all. And that's the standard restrictions on limited rights data. Under the DFARS, interestingly to note, it's permitted to, subject to notification of the contractor, can be used for emergency repair or overhaul to foreign governments. And as I said before, support contractors, with restrictions and notification, such as an NDA or the other applicable FAR clause that restricts the information dissemination. As long as the support contractors agree to those provisions, they can utilize your limited rights technical data. We say beware of encroachment because often is the case. It's happened with a client of ours a few months ago. They had performed at a job site in New Mexico for probably 15 plus years. The government decided in its wisdom to award to another contractor. That contractor came in. The government thought it had the correct solution and the ability to use the contractor's limited rights data. Unfortunately for the government, they did not. That limited rights data was only applicable for support contractors. This was an entirely new contractor designed to perform the work, supposedly using its own technology. But this new contractor, the new awardee, was expecting to rely on the incumbent contractor's technology solution. Unfortunately for the new contractor, they did not have the ability to use our technology without our permission, and that became a big problem for the agency. We should finally note that the FAR permits outside uses as listed in the contract, so be careful and scrub your contract so you know if the contracting agency put any particular uses for limited rights data in the contract, either in special flow-down clauses, and you probably find that in Section H, which are the special clauses, or Section I if there's some modified clauses set forth there.
In the next category, you can also specifically negotiate license rights with a specific license agreement. These are rights negotiated between the government agency and your entity. The one proviso, they can't be less than limited or restricted rights Limited is for the technical data, and restricted rights is for the software. You can tailor it so it's narrower than the government purpose rights, but that's kind of the constraint under which you can operate. But it's still sometimes helpful. There could be circumstances where it's not more narrow, but there could be advantages where you have provisions in there that are advantageous to you. They're not less than what would be limited or restricted rights, but they could be helpful to you as an entity, certain things that you need. The next category is for software. It's kind of a restricted rights. This is a category that is restricted to software, such as you can only use it on one computer or your terminal at a time. That's not time shared. This is what the government can do. They can transfer to another agency's computer. They can make copies for archive, backup, and modification. They can modify the software. Disclosure to service contractors to correct deficiencies or troubleshoot or for tactical situations. They can disclose to contractors for emergency repair and overhaul. And they can also, there's a right to unlimited rights in certain types or funded software. But overall, it's relatively restricted. It's very comparable to the type of restrictions you'd have. It's not as restrictive as, let's say, a major software vendor, but it does provide some protections and certainly much better than unlimited rights. Next slide, please.
For those of you who are familiar with government contracts, you're probably aware of FAR Part 12, which deals with commercial item acquisitions. FAR Part 12 really came into play in the mid-'90s with the Federal Acquisition Streamlining Act. And basically, the government wanted to more closely mirror the commercial marketplace in its acquisition policies, procedures, and practices. I don't think the government is ever going to get there as to have a complete similarity with the commercial marketplace, but they've strived to get closer, and FAR Part 12 was designed to do that. In order to be a commercial item, which allows for more streamlined acquisitions and more commercial-like terms and conditions, you have to satisfy the definition of a commercial item. That definition is found in 2.101. Real briefly, it's certainly a more expansive definition than commercial off-the-shelf items. You don't even have to have a sale of the product to be a commercial item. As long as it's offered for sale, license, or lease in the commercial marketplace or to the general public, it will satisfy the commercial item definition. It may include evolved products through advances in technology or performance that aren't normally commercially available, but those new enhancements to the product still will qualify as a commercial item. And it can also include product modifications to a commercial product, even though those modifications may not currently be available to the commercial marketplace. It's a much broader definition than even what's on the screen here, and for those of you interested, FAR Part 2.101, it's listed alphabetically. You can see the commercial item definition. It's about a page or a page and a half in the regulations, and it's worthwhile taking a look at. Certainly, as I mentioned, advantages to contractors in using commercial items is certain FAR and DFARS clauses. Standard clauses may be omitted in its entirety from the contract. There are only a handful of clauses that are required to be included in the contract under commercial items. Much of what you see in this, what we call flow-down clauses, and usually it's a FAR or DFARS followed by a number, and then the title of the clause with the date of effectiveness, and then you see pages and pages of these flow-down clauses. Most of those can go away in a commercial item acquisition. And if you can, to take advantage of that, these standard commercial licenses should be used as well. This discussion is about IP, intellectual property, and if you can qualify as a commercial item, you can use your customary commercial license as a company when doing business with the government. Now, I will say the government will not necessarily, as I mentioned before, indemnify contractors, and so those licenses often have to be modified. But the protections of your intellectual property, who can use it, how it could be licensed, things of that nature, and the restrictions on the use certainly can be transferred over to the government through a company's customary commercial license agreement. A couple citations for you. We often get asked, and I meant to put them on the slide, so I apologize, but for commercial item treatment of computer software and technical data under the FAR and DFARS, we mentioned the definition at FAR 2.101, but if you were to look at the treatment for computer software and technical data, let's just start with computer software. If you were to look at the DFARS, it talks about the use of your standard commercial license agreement. At DFARS, it's in the regulation at 227.7202. That's DFARS 227.7202. In the FAR, you can look in two places, FAR 12.212 and to a lesser extent, FAR 27.4053. There is a clause known as FAR 52.227-19 that deals with restricted rights for computer software. That is not a well thought out clause. Essentially, it gives the government restricted rights, and you should try and avoid using that if at all possible. On the technical data side, FAR 12.211 expressly states that contractor and the government should use standard commercial license wherever possible. And so that's something that you should try to pursue when working with civilian agencies. There have been some recent changes in commercial technical data rights due to the time of the program. Now, I won't necessarily go into those. Those can be found in DFARS 252, 227, 7015, and 7013. If any of you have specific interest in those, by all means, if you just send us an email, we can get back to you right away with those citations and also a brief description of those new additions. And finally, our key licensing considerations when dealing with intellectual property and the federal government and also in the commercial context. I think it's important to note when you negotiate license agreements with the U.S. government and allocate your rights accordingly, know what you can agree to with the government and what's available to be negotiated and what the government cannot change or not negotiate. I mentioned indemnification as a perfect example. The government generally does not indemnify contractors unless there's usually a statutory basis to do so. So arguing about indemnification is something that is often fruitless. There are some ways to have some language in the contract or in the license agreement that talks about indemnification. If those are big issues for you and your company, by all means, let us know. We're happy to provide you with some discussion on that. And certainly, Kevin mentioned at the outset, as I've always talked about with clients, making sure you mark your technical data and computer software with the proper restrictive legends is critical. Failure to do so, you can lose your rights to that technical data and computer software, and there's no recourse if you don't mark your technology accordingly. I'll let Kevin sort of finish up the program with some commercial red flags and some additional issues about patent protection, and we'll take any questions after that.
Yes, and some of the commercial red flags would include just basically, having a feel for who you're dealing with, the size of the entity. Make sure you know exactly, how it's protected, where the money came from. Make sure you mark it correctly. Make sure you follow through all the patent procedure. Make sure you've notified the government. Consider them to be kind of your partner in this if they're financing it, and therefore you need to notify them. You can't let anything drop. You have to act timely. Getting a patent is a monopoly. It's something that gives you an advantage, and so therefore you have to kind of comply with the rules and regulations in order to obtain that. There's a trade-off to have a monopoly, and you have to comply with that, and so that's very important. So just keep that in mind as far as the patenting, and also where the money came from, how to separate it out, how to think strategic to make sure you maximize what falls into the limited rights or restricted rights, to maximize that and to minimize what goes in the unlimited rights. So, it's really a privilege to be here, both for Jeff and myself. Are there any questions, and both online and here?
And we have a few questions here, and I will just repeat the questions as they've come up on the screen. The first question is, what if the Buy America Act or the Trade Agreements Act clause is also in the contract? you can produce in China. Is that correct? The answer is generally yes. I mean, China is sort of the bad country, the boogeyman, when dealing in U.S. government contracts. Now, if the Trade Agreements Act clause is in the contract, start with the Trade Agreements Act. If the Trade Agreements Act clause is in the contract, and you source some material from China, but that material then is substantially transformed in a Trade Agreements Act country, you may be able then to sort of provide that product to the government under that scenario. But when you hear China, in terms of government contracting and Buy America Trade Agreements Act compliance, that is usually the bells and whistles go off, at least in my head, that we got to take a look at the sort of the case-by-case situation and the facts of the particular sourcing or acquisition to make a educated decision. If the person who sent that question and has further questions on that, by all means, let us know. We deal with that all the time, something that we can at least talk to you about more fully. But, once you see China, it generally raises a red flag, and the question, it can't be produced in China. I assume that's manufactured in China, and if that's the case, the item can't be sourced from China because it would violate the Trade Agreements Act and certainly the Buy American Act as well.
And there's also things to keep in mind as far as software. Make sure that in some cases you need export licenses and things like that, and so some to kind of confer, and make sure you've got legal analysis as to where the product originated, if it's a U.S. product, where it's going, and things like that, because there's a lot of legal landmines in this area.
The second question, Kevin, is where do we find the markings to put on technical data and computer software? And in some ways, I tell clients and companies, this is not a time for creative writing. You don't have to write the restrictive legends yourself. Those rules and those restrictive legends are right in the FAR and DFARS. It's right under the clauses, FAR 227-14, the rights and data clause, and under the DFARS, 252.227-7013 for technical data, and 252.227-7014 for computer software. Those restrictive legends are right in those clauses. And as I said, it's not a time...
Which should be listed in your contract.
Yes, they should be listed in your contract, and you should just take those clauses and use those clauses as is, because once again, simply marking proprietary and confidential on the clauses on the data or software itself, it means nothing to the U.S. government. And as Kevin said, it's been very enjoyable talking to you today. If there are any other follow-on questions, feel free to send Kevin or myself an email, and we'd be happy to answer those for you. With that, we conclude our webinar, and everyone have a nice day and evening. Thank you.
Thank you very much.